everyone. My name is Alexandra Havrilishin. I'm a staff attorney at Legal Assistance for Seniors, and welcome to this presentation on protecting health and home legal information about documenting healthcare wishes and about tenants' rights. Legal Assistance for Seniors, if you don't already know, provides free legal services to seniors in Alameda County. We also provide community education and healthcare counseling. Here are some details about our impact. And here is some information about our health insurance counseling advocacy program, which provides free counseling on Medicare. So we'd love to hear from you. Who are you? Are you a caregiver, a senior, or a case manager? And I will give people a moment to answer. It looks like we have case managers and other on the line. So I understand this presentation though is being recorded, and there may be seniors and caregivers who will be watching this recorded version. So that is helpful to know. As a disclaimer, this is an educational session where we are providing legal information. We are not providing advice in this session. Although Kate Doyle and I are both attorneys, we are not your attorneys, so we cannot provide you with advice on your specific legal situation. If you are a senior in Alameda County, you're welcome to call our intake line and go through the conflict check and intake process. What we can say is that it's always important with legal issues to act quickly. If you think you might have a legal issue, don't delay reaching out for help because your issue might be time sensitive. So I will pass it on to Kate Doyle, who is a supervising attorney at Legal Assistance for Seniors, to talk about protecting health.
Thank you, Alexandra. And I think you have the control of advancing the slides, right? So yeah. So yes, today, although there are many advanced planning topics I could be speaking on, today specifically I'm going to be talking about documenting healthcare wishes. Later on, just to give you the lay of the land, I will try to put it into context with all the other potential areas that you or your clients might want to be thinking about when they're thinking about how to do advanced planning for while we are alive and after we pass. So next slide, please. So initial questions, why plan now? Well, of course, it's always good to be prepared for the unexpected occurrences such as accidents or illnesses. I like to always say, even my children, I say they should have advanced healthcare directives. Anybody who's alive, who's 18 or older, I would suggest having something in place. And again, we can get into the details of what that would entail, but having something in place so that your wishes are known. Of course, it doesn't mean that if you don't have an advanced healthcare directive, a doctor's not going to follow wishes, but because it's a directive and it is a legal document, but again, the healthcare system comes into interaction with this document. And so, of course, a doctor would always be acting according to what is they deem medically appropriate also. So then, yes, ensuring that your wishes and preferences are known and respected, because if you don't say it, nobody's going to know if you're in a position where you're not able to speak for yourself, regardless of your age. And then, of course, as we get on in years, planning documents can help prevent elder abuse. We'll be talking about naming agents and people who can step in for you if you wish and can make your wishes known. I think we also might say that it helps prevent conflict. There could be conflict with family members or people who care about you. If your wishes are known, then it prevents them from arguing over what's going to happen. So next slide, please. So this is just a we feel you planning for the future. It's never easy to think about a time when you need to help taking care of yourself. So if you make plans now, that'll help. The planning will help protect you when the time comes. But we're all in the same boat. We all avoid things like that. So now into the meat of the matter. What is an Advanced Health Care Directive, AHCD? The graphic that you see there is an example of one by the California Medical Association. We tend, with our clients, we tend to give those out for them to go over with their doctor. But as you'll see, there's many different, there's not one form, but when it's filled out and filled out correctly, it is a legal document. Again, the medical system still comes into interaction with it, but it is a legally effective document. It functions to help make sure your healthcare wishes are known and considered when you are unable to speak for yourself. I don't think we have in here, but the actual form this is just lawyer nerdy stuff, but the probate code, section 4701 is where one finds a suggested form for the Advanced Healthcare Directive. Again, it doesn't have to be in that form. It does not have to be in this form of the Advanced Healthcare Directive kit from the California Medical Association. It can be in a form done by, if you go to an attorney to have one done. There's not a required form, but as you'll see, there are required signing rules to make it effective. Next slide, please. So the Advanced Healthcare Directive lets you appoint an agent. When as lawyers, we talk about the principal being the person, the patient, the client, the person whose wishes are going to be followed. And then if they have a trusted person, they can, but they do not have to appoint an agent, somebody who can step in and speak for the principal if they are unable to. There's also the ability to name alternate agents or multiple agents, things like that. It really is the person creating it is in control of this. So in addition to naming an agent, if you wish, it also serves to give instructions about your health care. And when I was preparing for this, I was like, what is healthcare? Because we throw these terms around, and in this context, it's physical care and mental health care. So, however, because there's always a however, in this context, an agent cannot step into your shoes to make decisions regarding committing you to a mental health facility, regarding giving consent for convulsive treatment. I'm not a doctor, so I don't know what all these things are, or a psychosurgery, or consent for sterilization or abortion. So there are limits. Just be aware. You don't have to remember all of this, but that is what healthcare comprises. And it also lets you express wishes if you want, and you don't have to, about organ and tissue donation. Next slide, please. So again, appointing the agent is optional. If you do decide to appoint an agent, it would be somebody who would then be in a position, if you cannot speak for yourself, who can make healthcare decisions for you, except those ones I just listed. can make personal care decisions for you. I guess thinking personal care is anything you can think of that, I don't know, haircuts and things like that, that don't have to do with healthcare, just sort of preference things. Arrange for your housing. This is a big one. If you're not able to decide where you live, that is a decision that the agent is authorized to make on your behalf. Of course, again, using you assuming that you choose an agent who you trust to be familiar with your values and your wishes and beliefs, and to act in accordance with that if it isn't actually explicitly drawn out in your directive. They can also hire in-home help. They can open your mail, personal mail. They can authorize donation of organs, tissues, and parts, authorize autopsies. And although an advanced healthcare directive really is effective only during our lifetimes, there are certain acts that the agent can then follow through on after one passes. So, funeral instructions and directing disposition of remains. Again, your agent must always follow your wishes, or if they're not explicitly drawn out, what you would do if you could make to the best of their ability, what you would do if you could decide. Next slide, please.
Hey,
I see
Caitlin.
Susan has a question.
Sure.
So, this is while you are still alive. These decisions you're making are to affect you while you're still alive. When does your agent get involved in making these decisions? I mean, do you decide, you the principal, or does your doctor come in and say this person is no longer able, and that decision is taken away from you? Like maybe you
Mhm.
still think you can do it, kind of thing. So when does this actually become operative, if I
Good,
could put it that way?
great question. So again, lawyers always like to say it depends, because it always does depend. The 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 person who creates the document, this is their script, so they can say anything they want in it. Typically, what is instructed is that only if I cannot make decisions, and if a doctor determines that I'm lacking capacity, you could say one doctor, two doctors. Um, it really it's up to you have to read the actual document, and that will be your roadmap to determine when the agent steps in. So that's the answer. Look at the document, but it typically is linked to capacity, cognitive capacity. It could be linked to other things. I mean, because you could just be unconscious, or have had a stroke. So, um,
Got it. Can I jump in there as well, Miss Caitlin? Sorry, answering that
yes.
wonderful
Oh,
basic
please
program,
do.
man. Good to hear
Yes.
from everyone. Yeah, as well. So, we recently had a case with a gentleman who lacked capacity, and from that place, where do we go to
Mm,
support them if
yeah.
it's reported that they do have funds, they do have maybe access to some insurance situation that they have paid into, but they
Yeah.
have not created their advanced directives. Where do we
Yeah.
go from there?
So, yeah, so there's somebody who didn't see this presentation and didn't say, I got a plan for my future. Right. So, all right. So we're getting into the area I figured we would a little bit. So this is my disclaimer. So legal assistance for seniors, where Alexandra and I work, we are in the local rules. We are appointed by the court to represent people who are proposed conservatees, which is a legal process. Um, and because we are in the local rules to represent people who are proposed conservatees, we tend, or we really cannot. It's sort of, we don't, it's not a direct ethical conflict, but if since we do get appointed all the time, we would end up conflicting ourselves out if we were to give advice to people on how to get a conservatorship, because we don't know, maybe our client would say, why did you tell somebody else how to get conserve me? I don't want to be conserved, if that makes sense. So that's my preamble. So I can't give advice in a specific case, but I can say in general that if somebody has not created this document and then they lose capacity, yes, through a stroke, which again, sometimes with strokes, people can lose capacity and then it can come back. It's not like with Alzheimer's where it's permanent and progressive, but typically they're going to be in the land of conservatorship, petitioning for conservatorship. They're going to have to, yeah, reach out to I mean, they can't reach out, but whoever is concerned about them is going to be reaching out to get an attorney. And because at that point, whoever the concerned person is legally is a sort of an adversary, even if they're helping in ethical legal terms, they're considered an adversary to the senior that we'd be helping, because we don't know if they want their help or not. So, but does that answer the question?
It kind of does, but even if they don't consent to that service, that can take over the situation and steer them in the direction needed to go.
That conservatorships, and I believe we have some slides at the end, but for today's purposes, it's probably, yeah, all you need to know is that yes, if there is no advanced healthcare directive, then it's a court proceeding, which, is money and it's public, so it can be embarrassing and all of that other stuff. But yes, it would be conservatorship, which is a court proceeding.
Got it. And if there's no family member present, if there's a family member present, can they support in steering that if they have not been given the permission? Or how does that work?
They can consult with an attorney and they can instruct them who is allowed to petition for conservatorships. Like there's certain rules about if you're a non-family member and you're a creditor or a debtor, you can't. But again, they would be asking an attorney or self-help to guide them.
Speaking of self-help, because attorneys are so expensive, are there any good booklets out there that can sort of guide people where to start? If you're a case manager or you're just a good Samaritan and you know somebody doesn't have an agent, what are the steps besides calling an attorney and starting an expensive process? Is there anything laid out you can read about, you can check boxes to figure out where you are in this process?
Great question, but for two reasons, I'm going to say that probably all I can say is that they should talk to an attorney, just because in general, I always like to, if it's a legal issue, I always say you don't have to, but we advise you speak to an attorney. And yes, I understand they're expensive and difficult. But also just because we'd be getting into a territory where I think it's sufficient for me to say it's conservatorship territory, speak to an attorney, and really we can't say much more than that, honestly. Yeah. And I know, believe me, as a person, I know these are really difficult situations because we do get calls from people who are wonderful family members who want to support and help. And at our office, all we can do is speak to the senior, him or herself, and they say what they don't have capacity, and we say, we're sorry. That's all we can offer. So it's hard. Even if I know the answers and even if I want to step in, I can't. So.
Hi, Kaylin. I just have a question.
Mhm.
I'm Anitra from Daybreak.
Hi.
And hi, how does this particular document differ from a person who has a medical power of attorney? Like, do they still need this document in place as well?
So honestly, these are all just terms. It's the same thing. They're called
Oh,
different things, and in different states, they're called different things. There's things living will, which is the instruction part of it. This is a medical power of attorney. It's
Oh.
advanced healthcare directive, isn't it? It's confusing.
Yeah.
It's alternately called a medical power of attorney for medical decisions, whatever, but POA, same thing. But
Okay.
it's the power of attorney for medical decisions is specifically because there is an agent appointed, whereas today we're talking about advanced healthcare directives. They can just be your wishes, like a living will, like this is what I want.
Mhm.
I'm not naming an agent. This is just my wishes so that people know. And there's no agent. It's sort of like directions right to the doctor. Although I think in practical terms, I have heard, I mean, this is not legal advice, but I know that doctors tend to consult with, if there is a family member, they do tend to consult with family members, I think,
Mhm.
regardless of whether there's a advanced healthcare directive. But
Before you go on, Anitra, or can I step in now? Are your toes still down there? Am I going to step on your toes now?
No, no, no.
Okay, okay.
Heard my
So I'm
question.
looking up, I'm looking up, I'm Googling, you know how that is, and I find legal legacy law solutions, okay? And it's got a whole section about conservatorship in California, okay? And it's got a table of contents. What is it? How does it differ from guardianship? What are the proceedings? How do you obtain it? Would you at least be able to say, Caitlin, it would be worth it to go to some of these kinds of websites to get a beginning to before you actually hire a lawyer? Does that make sense?
yeah, it makes sense what you're saying, but again, you're going to say, "Oh my God, she's such a lawyer." I cannot, without previous, because of the subject area and because we have not previously vetted it, we don't like and there are places out there, they're called trust mills, and they could very well help, but there's no way I can recommend them,
Oh yeah,
honestly.
and
But
not a
but
specific. Yes,
yeah,
of
yeah.
course.
So so I don't mean to not be helpful, but
I
Yeah,
if
yeah.
I
you
think to alleviate your concern about cost, Susan, I think I can share that the Alameda County Bar Association will, most of the lawyers who are on their panel will do a free consultation. And from there, the person can decide whether they want to hire. So it's, it's not necessarily like you're committing long term.
that's
Okay,
a
well
great point.
that is very helpful. A free consultation is sort of how lawyers often work, and that they have a duty bound to do that for the community. Is that,
I
can I?
don't think it's a duty, but a lot of lawyers have their business structured that way.
Yeah, yeah, so that there's no commitment on either side, but
Thank you.
yeah. So the next slide, please. We may whiz through some of these. So then who you can appoint as an agent, anyone, and I realize, I mean, I get it now, the focus today, because, and I understand for you all, it really is somebody who has never appointed the agent, and what do we do now? But at least you'll have this, you'll know if you're trying to encourage one of your clients to appoint an agent, at least you will have this information to kind of coax them along if they still have capacity. You can appoint almost anyone 18 or older, someone you trust, of course. These are, big decisions that they have to make. You can name alternates. There's professional fiduciaries out there, but again, that's money, and a lot of times it's not necessary. It's overkill unless there's nobody else in the world and the person has money to pay a fiduciary. But and then there's some rules that are self-explanatory about who may not be an agent. Next slide, please. So then agent issue aside, then you get into the healthcare instructions. That's the actual stating your wishes to the best of your ability. You may not cover everything, but you're going to be covering a lot of things. And I tend to say with these things, because nowadays, especially, it is so in depth and with technology, biotech advances and everything. I'm not a doctor, so I don't discuss this with my clients. I'm not a bioethicist. I'm not So I suggest they discuss with their doctors, they discuss if they have a religious persuasion, they can discuss it at church, they can discuss it with a counselor. These are personal decisions, not legal decisions. So that the actual substance is a very personal matter. But any next slide, please. As is organ donation, and this goes into a lot of detail about the organ donation portion of it. I think most salient point is if you leave the donation section blank, your agent or another state authorized agent can make the decision to donate your organs. So be sure to fill out that section to make sure your wishes are followed. So basically, okay. So then, okay, now today, really, this is the big lawyer part of this today is completing it to be sure that it's signed as executed as it needs to be so it's effective. So it must be notarized, notary public, signing it in your presence when you're signing it, or two witnesses, and there's requirements on who can be witnesses and who cannot. And if it's in a nursing home, actually it's called, the term of art in the code is skilled nursing facility. There also has to be either a patient care advocate or an ombudsman who signs along with the agent. I think they can be one of the witnesses, or I may be wrong about that, so don't quote me. And just so you know, we were talking about this. It seems odd, but if it's an acute care, and I think maybe you tend to sometimes deal with clients who are in the hospital, like acute care facilities, the same requirement isn't there. So you don't, to my knowledge, you don't need to have an ombudsman or a patient care advocate also witnessing the signing of an advanced healthcare directive if somebody is in an acute care facility. I was wondering why that might be, but I don't know why the legislature set it up that way. But just know that, again, I think it's in the skilled nursing facility context, they just want to be sure that there's not undue, maybe because in that context, there tends to be more opportunity for predators and people to come in who might be unduly influencing a person and getting them to sign things that they're not fully aware of or ready to sign. So next slide. And here are we have listed here where you can find sample forms. Again, you don't have to have an attorney to create any of these. Usually I direct people to if they don't have a form, talk to your doctor. Get your doctor's form, go over it with your doctor. It's really a medical one-on-one with a doctor situation in my mind, but just being sure, as we said, that it's signed correctly. Next slide, please. And then as a side note, there is this other document called Physician Orders for Life-Sustaining Treatment. That is not, like for today, it has nothing to do with us, with lawyers. Like you don't go to a lawyer and say, make a post for me. This is a doctor to patient kind of a situation. Next slide, please. And it is very specific regarding your resuscitation preferences. So I don't know if you've visited clients who are, hospitalized. Sometimes they have it posted above the bed, the post. But in theory, I think it is supposed to, well, it talks about specific medical interventions and tube feeding. Next slide, please. In theory, it's supposed to complement an advanced healthcare directive, but it may or may not. Like you might have an advanced healthcare directive that you have since gotten rid of, but it really, again, it functions separately from, but one would hope in concert with your wishes under your advanced healthcare directive. And again, it's really a doctor's order is what it is. So, and there's no way for you to appoint an agent under a post. It's really just your doctor is ordering something. This has nothing to do with appointing an agent. Next slide. And then this I'll go through quickly because we are going to run out of time. So today we were talking about advanced healthcare directives that one would theoretically want to put in place to prevent having to get the conservatorship that you are all talking about and concerned about. And so typically, as part of planning for the future, it's not only the advanced healthcare directive, there's also durable power of attorney for finance, because that we just talked about healthcare today, but there's also DPOA for finance. And we won't go into it today. I just wanted these in here so you're aware of them. Next slide, please. And this goes into all the details if anybody wanted to find out about what a durable power of attorney for finance is and how they function. Next slide. And then, as I say, advanced healthcare directions and DPOAs are parts of a larger estate plan, which could include a will or a trust, depending on the assets that a person has. You can consult with an estate planning attorney to discuss these documents. So they're all aimed at ensuring that your wishes are carried out during your lifetime and after you pass away. Next slide, please. So then once everything's completed, you do want to keep it in a safe place. I know we don't have here, but there is a state registry where you can register your advanced healthcare directive. It is under probate code 4800. Again, I'm not necessarily recommending that. It is something where your private information is going to be held by the state with your social, like, again, that's a personal decision, but it could make it easy for your agent to get access to your wishes if they can't, for some reason, they can't find it. I don't know how useful these are, honestly, the registry. Next slide. And then, yes, best time is now. Don't wait too long, because as you know, the concerns that you have, it sounds like you're seeing people where they might have waited too long and never made one, and then they're stuck. Yeah, with a sort of embarrassing, public, expensive proceeding called a conservatorship. Next slide. And then again, we've already discussed capacity. So this is for another day, but it sort of came up at the beginning, you know, this is the elephant in the room, is there capacity or not? Next slide. Next slide. So, and again, if you don't have these documents, yeah, then you're in the land of conservatorship. So, I think that's it, because I want to give Alexandra time to, and maybe we can, I think for your questions, you might want to linger on this conservatorship slide, even though I can't give advice. You can always read the slide.
And we will, if we have your permission, folks from Legal Aid, if we will include that in our next newsletter, the slideshow for folks. So speaking of lingering on it, that would be great if we could do that and people could take their time to look at it in our next newsletter.
And is there a way this can be shared with us here?
Today?
Yes.
Yeah, a PDF version of the slides.
Yeah, beautiful.
Yeah.
Yeah. Yes.
I'm
yes,
fine
ma'am.
with that for the tenants section.
And
God.
same for my section. Yep. Anything to help.
I'll send that over to Susan and Wada.
But are we going to have a Q&A session here?
Yeah.
We're going to the next section Alexandra's going to do on housing. So I just
Okay.
wanted to get that, you know, so you
Oh,
got the
yes,
lay of the
ma'am.
land.
Right,
And
okay.
and just so everybody knows, we could do the Q&A today. And also, if you ever want to contact us, you know, if we're talking about a specific case, we would have to do a conflict check and be sure that we're able to talk to you. But if you have general questions, you can always contact us too.
Yeah, we're HIPAA compliant, so we'll generalize the topic and no specific names or anything like that. So I'm clear
Okay,
for sure.
sounds good.
Yeah.
Yeah, and I welcome your questions throughout.
First question, how do we say your last name? I'm sorry, I thought
Havrilition. I'm Alexandra Havrilition.
Have relations. Beautiful.
Yes,
Powerful.
thank you.
Go ahead.
So at Legal Assistance for Seniors, I practice in tenants' rights and also guardianship, but today I'll be focusing on our tenants' rights practice. So first question is, are you a tenant? LAS helps tenants in Alameda County, and for our tenancy practice, that's defined as 65 years and older. Wait a minute. Sorry, there's a mistake on the slide. It should say 60 years and older for tenants. We do not assist landlords with their issues related to tenants. And that's because of our funding. So you might be a tenant even if you don't think you are. A tenant is any person who pays rent or other compensation to the owner of the property. So this might be in the form of work, in-home assistance, helping with groceries. You, question for any of you who are tenants, feel free to raise your hand. Do you have a copy of your lease? I don't know if we have tenants in the audience today, but just take a moment to contemplate that if you're tuning in, to the recording. If you do have a copy of your lease, then we definitely recommend that you keep it in a safe place. That said, you might be a tenant even if you don't have a written lease. If you're at the outset of starting a landlord-tenant relationship, then we do always recommend that you get a written lease because it can make it easier down the line if problems arise. Then it is clear in writing what the agreement between the tenant and the landlord was. Also, if you do have a written lease, we recommend that you read it. This is an important document right along with something like your driver's license, your social security card, your birth certificate. This isn't something to just sign and throw away. This is something really to keep in a safe place because it has rules and regulations in it that you need to follow as a tenant in order to protect yourself against eviction. So an overview of tenants' rights. A tenant, this is not an exclusive list, but these are some of the most common issues that come up in our practice. A tenant does have a right to get a copy of their lease. So let's say that a tenant signed it and didn't know at the time that this is actually a really important document, and so they no longer have a copy of the lease. They do have the right to get a copy of the lease from the landlord, and one of the landlord's duties is to keep copies of all leases on all properties. As a tenant, you have the right to know the name and address of your property manager or other person to whom rent is due. So the property manager sometimes is the landlord, but in a bigger operation, the landlord might contract out to a property manager. A tenant has a right to a safe unit. We'll get more into what that means. A tenant has a right to timely repairs. Usually, so the way the code is written is repairs must be made. The landlord must make the repair within a reasonable time after being notified of the need for the repair. Usually, this is around 24 hours, but it depends on what the issue is. So if it is an overflowing toilet, then the landlord has a duty to repair it as soon as possible, faster than 24 hours. If it is something like fixing a roof where there's a long backlog of contractors doing shortage of labor, expensive supplies, it might be much longer than 24 hours. So that's why the legislation is written in kind of a flexible way. It says reasonable, generally meaning 24 hours. quiet enjoyment of the property. So that means that a tenant has a right to not be disturbed either by the landlord or by neighbors. So most leases do have quiet hours rules. So the neighbors have to abide by that. Part of the landlord's duty is to make sure the neighbors abide by it. And the landlord must give reasonable notice of entry to the unit only for a valid reason, like to make a repair on the property or to make an inspection about whether a repair is needed. A tenant also has the right to be free from discrimination, harassment, or retaliation for having asserted their tenant's rights. Tenants also have responsibilities, as I mentioned, to follow the lease. That's why it's important to have a copy of the lease. To follow California law, which includes, among other things, paying rent on time, not conducting illegal activity on the property. Tenant has a responsibility to allow the landlord to enter the property when there's a valid reason to enter the property. I mentioned that the landlord has a duty to repair the property. The tenant has a duty to notify the landlord that a repair is necessary. And this is more relevant towards the end of a tenancy, but a tenant has a responsibility to return the property to the landlord in a similar condition to the one that they got it in. Sometimes a tenant will have made a modification to the building that they see as an improvement, but the landlord doesn't necessarily see that as an improvement. So the tenant has the responsibility to return it to a similar condition minus some wear and tear. Now, what do we at LAS do? We help a lot of seniors in Alameda County. More than half of our calls are related to housing. And unfortunately, we don't have capacity to do full scope representation in housing matters. If we did that, then we would serve a much lower volume of clients. So most of our assistance is in the form of brief advice and counsel. So that might be 30 minutes to an hour speaking with a legal advocate after there's been a conflict check and an intake and a review of documents, informing them of what their tenants' rights are. Sometimes we will do self-represented assistance, like drafting a letter for a tenant that they will then give to their landlord. And sometimes we'll do limited scope assistance, for example, helping someone demand their security deposit back. And these are the areas that we help with. Habitability, so that means the right to a safe unit. Security deposits, getting them back. If fighting invalid rent increases, we'll review what the rent increase is, make a determination about whether it's valid under city, state, and county law, and then let the tenant know and maybe draft a letter to the landlord saying that it's not valid. Usually this is in the form of a self-represented letter just because of our capacity. And then we provide some pre-eviction help. So we do assist with reviewing an eviction notice. That's a notice that an eviction lawsuit might be coming, but the lawsuit hasn't actually started yet. If we review and the tenant doesn't necessarily know where they are in the eviction process, but we can do some intake questions and review the eviction paperwork they've gotten to determine where they are in the process. If the landlord has already started the eviction lawsuit, then we refer out to some of our partner organizations in Alameda County, Eviction Defense Center, East Bay Community Law Center, Centro, Bay Area Legal Aid, who do full scope eviction defense. That's not a promise that they will help that client, but that we know that they practice in that area. We refer out for full scope eviction defense or any kind of defense, even if it's self-represented after the eviction lawsuit has started. We refer out for this, there's a fancy legal term for affirmative suits. What that means is we do not sue landlords. We don't start lawsuits against landlords. We do not have the capacity to do that. That's something that takes a lot of discovery. To your earlier concern about cost, Susan, one thing that's helpful to know is that when we do provide a referral out to a private tenant's attorney, private tenants attorneys are generally work on contingency, which means that the tenant doesn't have to front the cost. The attorney collects payment from whatever the tenant is compensated if they win the suit. So a lot of people don't know that, so they're hesitant to reach out to a private tenant's attorney, but we think it's helpful to share that with tenants. Neighbor nuisance, so we generally refer out to mediators in the area for that. So if the issue is just with the neighbor. Forcible detainer, that's when a homeowner has been evicted after a foreclosure. Housing and economic rights advocates helps with that. And we don't provide financial assistance. So if someone is calling us looking for help paying their rent, we don't have money to give seniors to help them pay their rent. We refer out to 211. So to go a little bit more into detail about some of the areas that we do assist with. Habitability, this is a fancy legal term for the tenant's right to a unit that is fit for a human to live in. So that means a unit that is protected from the elements, from rain and snow and that kind of thing. So a roof that is working, keeping rain out. That means plumbing that works, gas that works, heating that works, electricity that is up to code and is safe, sanitary common areas, trash receptacles, a locking mailbox for each tenant, safe floors and railways, a stove and an oven to cook food. So if the tenant doesn't have these things, that can serve as a defense against an eviction lawsuit. That can be, the tenant can say, well, I didn't pay my full rent because the unit wasn't habitable. We don't recommend withholding rent, by the way. It's a complicated process. If the tenant is in a position where they think they might want to withhold rent because their unit isn't habitable, then we recommend they call us and we can better assess the situation and provide some guidance on what to do. The issue with withholding rent is that it can put the tenant in a place where they might be on the defending side of an eviction lawsuit. But we can help a tenant draft a demand letter to the landlord to demand that these things be fixed, because in any affirmative suit, which we wouldn't do the affirmative suit, but that tenant is going to need documentation that, like, the roof was leaking or the toilet wasn't working or whatever it is. The tenant needs to start documenting these things if they are problems, and the tenant does need to report those things. And it's best to report it in writing, because then there's a record. We get a lot of tenants calling us saying that their security deposit wasn't returned to them. So just to kind of give an overview on the newest rules around security deposits, for anything around any security deposit collected after July 1st, 2024 is limited to the amount of 1 month's rent. And once the tenant moves out, it must be returned within 21 days of vacating the unit. And if anything was deducted, the landlord must provide an itemized list of why the deductions were made. The law also in California prescribes reasons that security deposits can, what the security deposit can be used for. The landlord can deduct for unpaid rent, for damage to the unit that was caused by the tenant or the tenant's guest. And the landlord can deduct to return the unit to its original condition, even if the tenant thought that the way they changed the unit was an improvement. If the landlord doesn't return the security deposit, then the tenant can sue in small claims court. But before they start that lawsuit, they're going to need to try to settle the matter out of court in Alameda County. That's what the small claims department requires, that the plaintiff show that they tried to negotiate out of court. They tried to solve this issue out of court, and then it didn't work, so they came to court. So we can help a tenant draft a letter saying why they believe they are owed their security deposit, and we provide assistance with filling out the small claims forms. However, in the small claims department, there are no lawyers allowed. Parties can't be represented, so we don't go to court with the client. Of course, the person would still have to call our intake line and go through the conflict check process, and it does depend on our capacity too. But those are some of the areas we practice in, as well as assessing rent increases to see whether they're valid. Rent increases are complicated. Sometimes people will call us thinking that they can get a quick yes or no, is my rent increase valid? It usually takes me about an hour to research whether a rent increase is valid, because I have to look at the lease, the state law, the city law, and the county law. So starting with state law, there's something called the Tenant Protection Act that was passed in 2019, which limits a rent increase to covered units to 5% plus the consumer price index, or 10%, whichever is lower. However, that is not as simple as it seems, because note that I said this is only for covered units, and there are a lot of units that are not covered by the Tenant Protection Act. So we have to take a close look at the exemptions. Some of the exemptions include single family homes or condos, a building that was built within the last 15 years. So then we have to go to our database and look up the certificate of occupancy, owner occupied buildings, and most government funded housing, with the idea being that government funded housing has other regulations and protections that protect the tenants. Also, if the unit would fall under one of the exemptions, the landlord has a duty to provide a statement, very specific wording, to the tenant saying that the unit is exempt from the Tenant Protection Act. So the tenant is going to have to provide correspondence from the landlord for us to review to see if the landlord ever provided that required language. Then, in addition to statewide law, in Alameda County, here's a chart of cities that have additional rent control. And again, each of these cities has a list of exemptions. So as you can see, it's it's not a simple yes or no answer. It requires a fair amount of research, but that is an area that we, depending on capacity, may be able to assist tenants with. So thank you for your time. Here's our contact information, and I would welcome any questions.
Members who are living in inhabitable situations, and we have a certain person, he's in San Lorenzo, and he's in a place that where he is connecting a extension cord from his home to outside to gather electricity. And he's in a place where it's totally trashed. And he has also connected with so many different uh, community-based organizations that he has wheelchairs all over the place. So wheelchairs, walkers, and things of that nature, giving him um, DME, but he's still in a place where he has a dog himself, and he's in a place that there is no electricity and no running water. In that situation, who can we call to right immediately ensure that somebody comes to assess the situation and then place the responsibility in the proper place? How do we deal with a situation like that?
Yeah, so I can't comment on that specifically. He would have to call us or be referred to us, and we'd have to do a conflict check before I can comment on the specifics.
So
Um,
LAS specifically,
mhm.
LAS specifically.
He's welcome to call our intake line, and from there he'll be routed through the conflict check process and intake process. Or um, you can email me his referral. I will say, just to set expectations, we do not do full scope representation. So we wouldn't be suing the landlord. That's just not a service that we have the capacity to provide.
Also, if you could outline that full scope representation, how does that look? And is it something that has to be, do we have to get a lawyer or, you know,
Well,
specifically retain that lawyer to best support the mission?
So I mean, in general, I'll jump in also, Alexandra. I don't know if you're losing your voice, but um, I always say you can over refer to us, make referrals to us through elder abuse. What is it? Elder abuse at LASHICAP.org.
Yeah.
Because what we do is, since we are lawyers and we're trained to issue spot and assess a situation, assuming there's no conflicts, we're able to then, because we do know the community, we know the law, we can then direct the person to the right referral or referrals. So even like, I don't want you to be worrying about can they represent or not. We can definitely assess a situation and point a person in the right direction. So you can be sure of that if there's no conflict.
Yes.
We have, I believe, and I don't know who at your agency has it, but we do have a format. We have a referral form where it guides you through like everything to be able to then email it to us, so that from a legal standpoint, we can then, as I try to answer some of the questions you have, assuming there's no conflict with the person. So I don't know if you want us to provide you with a referral form that we have and the email address, because that's how you contact us to get the ball rolling, T. But definitely welcome anything where there's a potential legal issue. We definitely welcome the referral, and we'll do what we can if we
So,
can.
so legal assistance for seniors, and then it's also it's for dependent adults, correct?
Correct. The referrals that we get from Adult Protective Services, also under the Welfare and Institutions Code, they send us referrals also for, yes, people who are 18 to 64 who are dependent adults. Meaning, and that's a term of art, people who can't, because of whatever, even temporarily, can't enforce their rights or have trouble enforcing their rights.
You
Is
got it.
this individual below 60 years old, Antone?
Yeah, he's I think he's like 58. a little bit short of 60 years old. But again, he's in a place in San Lorenzo that has no electricity and no running water. And if somebody's in a place like that, who do we reach out to for that direct support?
Yeah.
Is it not legal assistance?
So, yeah, I'm just going to leave it at that because, again, if ethically, if we get too far into this and we find out there's some reason, hopefully not,
Yeah,
that we can't talk to the person,
yeah.
then it's not good for any of us. But definitely happy for specific cases for you to send it to our office. I mean, definitely.
And
Got it.
what
So
would be
an assessment place, so where we can send to you just for the assessment, and so you can bring back to us, the possibilities or whatever is there that we can best support this person with.
To set expectations, yes, theoretically, you would send us a referral. We would talk to the potential client. We would get their consent. Since we're attorneys, once we start talking to the potential client, then there's a seal, ethical seal around us and the client. If they say, yes, go back and talk to Daybreak about my case, we can. If they say, don't mention anything to Daybreak, then we can't. So that's, but hopefully everyone's working together and we would be able to.
Yeah, I would assume that we would want to get permission from that person to work with LAS and us and them. If they don't give us that permission, that makes things even more complicated.
All right, thank
It
you.
sounds like
Yeah,
it's
you're welcome.
possible, and hopefully it could be timely. But I look forward to hearing how this goes. Yes, and please do send us the slides and so on, so we have the information that you shared with us on the screen. And thank you. People we work with, it kind of really breaks your heart. And, we're trying to find as much support as we can. Thank you. We'll be in touch.
Okay, thank you.
Thank you.
All right,
Thank
thank
you
you all
both so
so
much.
All
All
right.
right. Bye-bye.
Bye. Take care.